Honorable Shri H.R. Bhardwaj, former Governor, former Union Minister of Law and Justice, perhaps for the longest tenure after independence, and was played a very significant role in setting up this institution. He was responsible for carrying out reforms in the service condition of judges in 85-86. He played very significant role in access to justice by instrumental in setting up Gram Nyayalaya all over the country, where justice at the doorstep concept was conceived. Professor Rajkumar, you all know him as a distinguished Vice Chancellor, and I like to call him an institution builder. In 5 years, this institution is now recognized not only in India but all over the world. It's a great tribute to him. He has done extraordinary work for this institution, and I hope he'll continue to do the same. Professor Erickson was a very distinguished diplomat. I'm very happy that Professor Rajkumar has been able to persuade him to come to this institution. What I can say in his case is loss of diplomacy is gain of the academic world. I am deeply beholden to Professor Rajkumar for giving me a very pleasant task of introducing and giving introductory remarks regarding my very distinguished colleague, Mohammed Baruna of the International Court of Justice. As some of you must have known about it, Justice Baruna has been re-elected as the member of the International Court of Justice for the second time. That speaks volume of his popularity, respect and admiration he enjoys all over the world. In my respectful view, he deserves a standing ovation, and I request all of you to give a standing ovation to him. He is a leading scholar, learned and erudite professor of international law. He is a diploma holder of the Hague Academy of International Law. He has lectured in the Hague Academy of International Law several times. He is author of many books. His well-known studies of international criminal law and role of international criminal courts. His another very important publication, International Law, on the law of nationality, then role of International Court of Justice. He was a very distinguished diplomat. He was ambassador and permanent representative of Morocco to the United Nations. He was chairman 6th Committee of Legal Matters at the 59th session of General Assembly of the United Nations, member of the UNESCO World Commission on Ethics and Scientific Knowledge, member of UNESCO World Commission on Bioethics and Scientific Knowledge, member International Law Commission, judge, International Criminal Tribunal, ad hoc judge in the ICJ, won many honors, awards and prizes. Some of them are very significant. I can't name all of them, but I'll mention a few of them. National Prize for Culture, Morocco, Medal for Culture, Yemen, the Knight of National Order of Reason of Honor. His long career, he has held many positions and polished every position with his creativity, brilliance, dedication, and human disposition. In my view, he is a judge by profession, professor by temperament, diplomat by choice, a researcher by habit, a gentleman by character, and a humanist by nature. He was responsible for making a great contribution to the International Court of Justice in his first tenure, and I'm sure he'll make even greater contribution in his subsequent tenure. We have divided the subjects. Judge Banuna would speak on the important cases which were decided by the International Court of Justice. I'll briefly tell you something about the functioning of the International Court of Justice and adjudication of the matter. Now, as most of you must be aware, that International Court of Justice is the principal judicial organ of the United Nations. It was established by the Charter of the United Nations, signed on 26 June 1945 at San Francisco, in pursuance to one of the primary purposes of the United Nations, to bring about peaceful means and in conformity with the principle of justice and international law, settlement of international dispute or situation which might lead to breach of peace. The permanent seat of the court is at the Peace Palace, The Hague, the Netherlands. Judges of the International Court of Justice are elected by General Assembly and Security Council. It is one of the most intricate and complicated and difficult elections where a candidate has to get absolute majority both in General Assembly and the Security Council in order to be elected. It is called the World Court, and the entire world has been divided, and there are 15 members from all parts of the world. There cannot be 2 members from one country, and once the members of the court are elected, they represent neither the government of their own country nor any authority. They are independent judges whose first task is to make a solemn declaration in open court that they will exercise their power impartially. It's not exceptional for a judge to vote against the position taken by his or her country in a case which is a party. There are many illustrations before the International Court of Justice. I'll not burden you with all that. And any country which does not have representation on the bench of the International Court of Justice, they have a right to appoint ad hoc judge for a particular case. In most cases, we have ad hoc judges. So, as a matter of fact, adjudication is normally done by 17 judges. President and vice presidents are elected by pairs every 3 years by a secret ballot. The law applicable to the court is defined under Article 38 of the statute, and they are governed by international convention and treaties, international customs, general principle of law recognized by civilized nations. Under Article 34 of the statute, only states may be parties in a contentious matter before the court. French and English are two official languages. The parties can choose in which language they would like to address the court. There is a provision of simultaneous translation in all the deliberation before the court. International Court is a court of first instance and a last resort. We work as a trial court, we work as appellate court also. A judgment delivered by International Court of Justice is binding upon the state concerned. All judgments are final and without appeal. The most important part of International Court of Justice, which is different from any other apex court of the world, is the intense deliberation which takes place before a judgment is handed out. I'll not go in detail of that process, but this kind of detailed deliberation is not there anywhere else in the world. I've studied many legal systems, but this kind of system is not there anywhere. Now, after the oral submissions of the parties are over, then within 14 days to 3 weeks, all judges have to submit judicial note, which is another form of the judgment within the specified time. And all that has to be deposited before the registrar on a particular date. It cannot be delayed by 1 minute. And if it's delayed by 1 minute, then you are not entitled for the copies of the judgment of your other colleagues. You are virtually out of the game. The point I am making is that this is the kind of discipline which is maintained in the International Court of Justice and other international bodies, that every step of the case is determined, decided by the parties in consultation with the registrar beforehand, and is put on the website. You will be surprised that even date and time of the judgment of the court is determined several years in advance, and the court has not defaulted even once. I can tell you the dates of all the cases where the judgment will be pronounced. The time and date is fixed. Now, this generation must cultivate this habit. My generation has failed, but this generation must cultivate this habit of delivering judgment within the time frame expeditiously. Whatever is the time frame, it has to be. The delay can never be part of the judicial system. The system will never acquire credibility if there will be undue delay in administration of justice. And this is because we develop a wrong habit from the beginning that judgment can be delayed by a month, 2 months, 3 months, 4 months. And at every stage of the civil trial or a criminal trial, you will find there is a normal request of adjournment. Because we do not cultivate a habit of working within the time frame granted by the court. Once a party is given 2 months time for filing his memorial, then is never that party would not file within 2 months. Or 4 weeks time is given to a judge to write judicial note. It has never happened that anyone has defaulted on that count. If it can be adhered to that precision at the international bodies, why can't it be done in our court, in our system? If you people are able to introduce this, it would go a long way in setting up the credibility of the Indian system. These are some of the things which I wanted to tell you. Time is very short, and if I go in detail of that, it would take a long time. But before I conclude, I'd like to tell you What is common between this institution and ICJ is that one Andrew Carnegie, a small messenger boy born in Scotland, was a very ambitious young boy, and he worked in Ohio Telegraph Company. And somehow he managed to go to the United States and got into steel business. He became the largest producer of steel in the United States. 49% of the steel was produced by his firm alone. Well, that's not significant. Significant is a man who had no background of law, man who had no background of any international arbitration, conceived of an idea that world is lacking, where there is no institution in the world where international dispute can be resolved. So he comes to Netherlands, where there were already some international institution, meets the Queen of Netherlands at The Hague and says, I would like to set up a temple of justice where international dispute can be resolved, so that in the world you may not have a situation of war and humanity may not be destroyed. And in 1903, Bhardwaj Sahib, he gave a check of 1.5 million US dollars in 1903, which would be equivalent to several billions US dollars now. This is one thing I find in common in both the institutions. Now, with that money, the Peace Palace was constructed. Peace Palace has 4 great institutions housed in one building. One is the Permanent Court of Arbitration, Hague Academy of International Law, Permanent Court of International Justice, and the world-class library. And not only that, from the remaining wealth, he had created 2,500 libraries in America and other English-speaking countries. Now, 66 million US dollars in 90s he had spent for libraries. And he thought the world can be educated only by establishing libraries all over the world. And in one of his books, he says, I don't want to be known as a steel baron. I don't want this tag to go along with me. I would rather known as a one who has served the humanity in the field of education. And in one of his very interesting books he writes, it is disgrace to die as a rich man. You leave problem for your inheritors. You know, that was the concept which needs to be emulated by all of us in some way or other. Thank you very much.